Sebastian.
My Lord, my Lady, yesterday my Lord Justice Mayles asked for copies of the notice of dispute, the trigger letter as it's sometimes called, and the request for arbitration. Hard copies of those have been placed on your desk. I was mistaken, they are included in the supplemental bundle. The reference is supplemental bundle 8.1 and 8.2.
Thank you very much.
That being said, I'm not sure if they were added overnight or not, so maybe my mistake was not so grievous.
Very good.
My Lords, my Lady, I have reflected on our exchanges yesterday overnight, and I'd like to communicate some of those reflections to you. My Lord Justice Popplewell queried whether a tribunal would have jurisdiction, even after a claimant had disposed of its asset, to decide whether a claimant was nonetheless a qualifying investor. Now, I have an initial point on this and then the substance. The initial point, of course, is that this situation is not the present case. That situation does not need to be decided in this hearing. But let me just explain why, by noting two variants of a jurisdictional objection based on a claimant having parted with title to its assets. One type of objection in that scenario is that the offer to arbitrate is only in respect of claims during the period when the assets were held by the claimant. The question of whether the assets were owned at the time of the commencement of the arbitration does not matter to the outcome of that objection, though obviously it will often be the case that, as a matter of fact, the claimant will still no longer have title to the assets at the time the arbitration is commenced. Now, the effect of this objection, if it succeeds, is that there is no jurisdiction to consider claims for breach where the claimant didn't hold the investments at the time of the alleged breaches. This is the jurisdictional objection that was referred to in Phoenix that we have looked at, and it was the one upheld in Bucklinghouse, which we will come to later this morning. One sees this objection cast as a jurisdiction ratione temporis point at times, although it is also characterizable as a matter of jurisdiction based on the interpretation of the BIT, just a straight treaty interpretation point, especially by reference to a treaty's disputes clause and scope of application clause, like what we have in Article 9 and Article 2. Now, this is the objection that both sides agree is available to the Czech Republic. It survived the application of Section 73 below. But it is subject to the point about whether it is properly jurisdictional, which is what the court will decide. If it is jurisdictional in nature, it is then for the first instance court to decide whether it is right as a matter of treaty interpretation and then apply it to the facts. The core point that I'm sure the court has, that what is being decided in this appeal is the question of characterization, not the question of substance. Now, the other type of objection, the second of the variants that I mentioned, is that a claimant must, subject to very limited exceptions, such as an expropriation or a forced sale, which we'll discuss later, continue to hold the assets at the date of commencement of the arbitration in order to qualify as an investor. If the claimant does not satisfy that requirement, it cannot accept the offer to arbitrate at all, and all the claims fail. That is regardless of whether it owned the assets at the time of the alleged breaches. Now, I will show you various cases today in which one sees debate about whether or not that is the proper approach to the interpretation of the treaty, but I'm sure the court will recall the cases of Alcor and Daimler that were touched on yesterday and in the skeletons. Now, what the correct determination of this objection is, whether based on the reasoning in Alcor or Daimler or otherwise, is not before you. That goes to the substance of the objection. It's not the question of characterization. And of course, there has been no decision on this below on the substance. And so it is for the first instance court to determine that point. I should note that the defendants say that we cannot take this objection because it is not live, and that is the subject of debate between the parties. But the reason why we are discussing these variants and discussing cases like Alcor and Daimler is because, as set out in my skeleton, they are another illustration of an objection based on a claimant disposing of its investment, giving rise to a jurisdictional objection in the Section 30 sense.
You've confused me. You say that's not a point before us. So this isn't a point you're taking, this second way of putting the objection.
The second way of taking it, we say, the Czech Republic says, is live in the proceedings, my lord. The defendants say it is not live and not open to us. But what this court doesn't need to decide is the substance of it, but only whether or not this objection, by which I mean the Stava June 2011 objection, which we say includes both the post-dating element, the alleged breaches occurring after the disposal of the investment, and the date of commencement element, i.e. not being an investor at the time of the start of the arbitration. We say that that is properly characterised as jurisdictional. So whatever the substance of the objection and its determination by the first instance court, that element is characterised as jurisdictional, which is the way that this appeal in our submission ought to be determined.
So if it's jurisdictional, you say you win the appeal, but the substance has to go back to Mr. Justice Foxton, presumably, to determine the substance or the merits of the point, which will raise very similar considerations, possibly even identical considerations to those which arise on the control appeal.
In relation to the first part of your question, my lord, the simple answer is yes. The substance of the appeal needs to go back to Mr. Justice Foxton. In terms of whether it raises identical considerations on the control appeal, I don't think I could say an unequivocal yes at this point in time. Indeed, I wouldn't want to trammel on what Mr. Dunny is going to say, but one can certainly see ways in which this objection on its substance would have different considerations to the control appeal on its substance.
Okay. Sorry, I think I interrupted, my lord.
I'm afraid I'm still confused. I had understood you to be advancing your argument as an argument that we had to determine that in deciding whether this issue was jurisdictional, you put it in two alternative ways. One is the offer to arbitrate is only an offer to an investor at the time of the commencement of the arbitration. Alternatively, if it's an offer to a previous investor, it is still jurisdictional in relation to the issue of whether that person is an investor at the time of the events complained of. If I understood correctly, those are both arguments you say that are live and that it is for us to decide, or are you saying that the first of those arguments is not live and not for us to decide?
I'm grateful to you, my lord, because it is important to clarify. The only point that is to be determined on this appeal is the characterisation issue. Are the objections which the Czech Republic has taken below properly characterised as jurisdictional in the Section 30 sense, or are my learned friends correct that they're just a matter of admissibility and therefore not open to court review under a Section 67 application? Now, in order to assist in the situation of that particular issue, the court and I have had a discussion about the substance of the jurisdictional objections themselves. And in doing so, I hope that that elucidates the nature of the objection, the proper characterisation of the objection. But in relation to the second part of your question, my lord, the answer is no. This court is not to decide positively whether it is correct on the substance of the objection that there is no jurisdiction for a tribunal at the date of the commencement of the arbitration, or in relation to breaches that post-date the disposal of the investment. Now, those are the two alternatives of the objection that the Czech Republic has put forward in these proceedings, but they have not been determined below, and so they are therefore not open to be determined on this appeal. When I refer to one of those issues being agreed to be live, that is what the parties' positions are, in respect to the substance of the objections when they come to be determined by the first instance court. And just to repeat that point, the parties are agreed that the objection that there is no jurisdiction over breaches that post-date the disposal of investment is live. The substance of that needs to be determined below. My submission to the court is that that should happen because that issue is properly characterised as jurisdictional. As for the alternative, the Czech Republic does say that the date of commencement point is live within the scope of its objection, but the defendants say that no, that is not live. That is not something that is part of the substance of the objection that needs to be determined below. That debate is there to be had, but if it is live, then it ought to be characterised as jurisdictional, and therefore it ought to go back to the court below. If it will help the court, I can take the court through the list of references that show that debate as to whether or not the issue is live, including the indication by Mr. Justice Foxton at the October consequentials hearing, where his lordship indicated that there needed to be clarity as to whether or not this issue would be live when it returns back before him, or whether or not it would not be jurisdictional and therefore it doesn't return back before him.
Well, I'm afraid I'm still confused. I entirely understand that the substance of the objections, as opposed to determination as to whether they're jurisdictional, is not what we're dealing with. So that if we have decided that they are jurisdictional, then it will be for someone elsewhere to decide whether on the facts the jurisdictional challenge is sound or not.
Yes.
So far, so good. But in determining the question as to whether the challenge is jurisdictional, it does seem to me that both of the ways that you have put the argument go to the question of whether it's jurisdictional. The second, what you describe as the second type of objection, namely, you've got to be an investor at the date of the arbitration. If that is right, then we have to decide whether that means that the question of whether Mr. Starver and in due course Diag were investors at that time is a jurisdictional question. I understand there's a debate about whether that aspect of the argument is open to you or not. You say it is, but what it's my fault, I'm sure. I don't understand at the moment why you say that isn't, as a jurisdictional question, a question for us. Namely, that's what the arbitration clause means. It means it's an offer to an existing investor.
And my lord, I don't think that your lordship and I are far apart on this. I think we are agreed that not only does the substance go back to the first instance, but what this court needs to decide is whether those two variants are characterisable as jurisdiction without then deciding if the jurisdictional objection succeeds on the facts. So in my respectful submission, the court would say, these are the objections. We have looked at the terms of the treaty and whatever assisting authorities the court wishes, and their proper characterisation in line with section 30 is that they are objections of substantive jurisdiction.
But I may have misunderstood. When you were initially identifying your two types of objection and saying that the second of them wasn't before us, I thought you meant we don't have to decide whether on a jurisdictional basis what the arbitration offer means is an offer to an existing investor, and that the question of whether or not they are an existing investor is a jurisdictional question.
I apologise, my lord. I think we have reached ad idem between us, and Mr. Dunning kindly indicates that I may have misspoken on exactly that sentence that your lordship said generated the confusion. So I think we are ad idem, and I'm grateful for the opportunity to clarify.
So we need to, as far as you're concerned, we need to address both those types of objections for determining whether they are jurisdictional. The second of those is subject to an issue, whether that point is open to you in this court.
Correct.
Is that right?
Yes. Thank you.
Thank you. I'm sorry to have taken so long to...
No, I'm very grateful for the clarification, because the delineation of what needs to be decided in this appeal, as distinct from what goes back to first instance, is a very important one to delineate clearly, so I'm very grateful for that exchange.
Can I put it in my terms to see if I've understood? Do you accept then that in order to decide whether the objection is jurisdictional, we need to interpret the offer to arbitrate in order to decide whether it is, on the one hand, an offer to anybody who has made a qualifying investment, or on the other hand, an offer to somebody who is a qualifying investor at the date of the commencement of arbitration, subject to limited exceptions like expropriation, or on the third hand, taking a strange beast, an offer to somebody who is a qualifying investor at the time of the conduct complained of. And we need to interpret the arbitration clause to come to a view about that. Those seem to be the relevant candidates. And once we've done that, that will tell us whether the objection is jurisdictional. Is that the exercise we ought to be doing or not?
My lord, yes. And your use of the word candidates, I think, is well advised, if I may say so, because it is the case of the Czech Republic that we are saying the objection covers two of those candidates and they are properly characterised as jurisdictional. And it is the case, as I understand of my learned friends, that the third candidate is the proper construction of Article 9. It means it's not a jurisdictional objection, and it actually excludes those other two candidates on the proper interpretation of Article 9. So I think I'm essentially repeating what my lord has summarised, but in essence, yes, those are the candidates that are before the court.
Well, you may have mischaracterised the case against you. As I understand the case against you, it is if the relevant candidate is anyone who's been an investor at some stage in relation to qualifying investment, then that's what the clause means, and it's an offer to that person in relation to whether he or she or it remained a qualifying investor. I don't think they say there's a third candidate as to the person to whom the offer is made.
And in that sense, I was taking my Lord Justice Mayall's summary as effectively a summary of the defendant's position. There has been a little bit of uncertainty as to the exact parameters of the position that is being articulated by the defendants. But I'm happy to adopt that for now and hear what my learned friends say. And if there is uncertainty about the correct characterisation of the defendant's position, we can address it in reply. But I'm grateful for that clarification. My lords, my lady, it was an important initial point to start with, so I'm grateful for that exchange. But in light of that, I'd like to now come to the substance of the question that my Lord Justice Popplewell posed. And the answer to that on the substance is no. And there are two reasons for that. The first, as we canvassed yesterday, is the treaty's terms. Article 9, as we recall, refers to arbitration of disputes with respect to investments. On that language, in my submission, the tribunal only has jurisdiction to decide a dispute if there was an investment at the relevant time. That also aligns, as we discussed yesterday, with Article 2. It aligns not only with paragraph 1 of Article 2, which says that the BIT shall apply to investments by investors of the other contracting party. That is a clear indication that jurisdiction is limited where there is an investment by an investor. But it also aligns with paragraph 2 of that article. That paragraph says that if there is not an investment by an investor, such as when a claimant disposes of its asset, then the treaty shall not affect the rights and obligations of the contracting parties. Now, if the arbitration clause is treated as covering a dispute regarding an investment that has been disposed of by the claimant, then self-evidently that would affect the rights and obligations of the Czech Republic under the BIT. Article 2 is therefore, in my submission, a clear textual jurisdictional limitation If there is no investment by an investor, there is no jurisdiction. The scope of the treaty is simply not engaged. Now, I should be clear in this regard on one point that I touched on early yesterday, but I think is important to repeat in the context of this question. That point is that it is not correct to say that after a person has disposed of its investment, that person is an investor. And the Czech Republic's case regarding whether, in this case, Mr. Stava can claim simply stands or falls on that basis. Now, I accept that there are cases where such reasoning is sufficient on the facts of those cases to dispose of the claim. But that is not a complete statement of the principle, especially when Article 2, Paragraph 2, is so clear that the Czech Republic has no obligations under the treaty when there is not an investment by an investor. But in my submission, that makes sense. As I said yesterday, it is...
It makes no commercial sense at all. The concomitant of your argument is that if an investor has an investment which is a qualifying investment, and then there are a number of breaches by the other party to the treaty, which would give rise to an arbitrable dispute, but he then sells his investment to somebody else, he can never arbitrate that dispute. That is the natural concomitant of your argument.
My lady, I embrace that.
You have to.
And indeed, my lady, and the reason I embrace that is for two reasons. One of specific jurisprudence and then one of broader context. The specific jurisprudence, as we will canvass later this morning, enunciates a principle whereby there is no jurisdiction in that situation unless there are specific circumstances that give rise to jurisdiction. And the examples that we have canvassed, but I'll come to in more detail in the cases, is where there is an expropriation or a forced sale.
That's an extreme example. But because you accept that there is that exception, it rather suggests that what you're saying is wrong.
With respect, my lady, I submit that that is not the case. And that is not simply because there is case law which goes to the point which I will come to this morning. But it's also because of the second point that I was going to raise, the point of broader context. The starting point in relation to jurisdiction over states is that there is no consent to jurisdiction. As a matter of international law, there is never a presumption of consent or a default of consent absent an articulation of that consent by the state. And in those circumstances, it's not surprising that states will only consent to arbitration of these types of disputes to the exact extent that they agree to it in the treaty. So when
if you're right, then doesn't my lady's example show that the treaty is not achieving its objective? So an investor invests in the Czech Republic, confident that he's going to get fair and equitable treatment, which he doesn't get. And as a result, the value of his business is destroyed. And he thinks to himself, there's no point in me continuing here. I'll flog off the assets for whatever I can get for them and scrap value or whatever it may be, and go and try and build up a business somewhere else. Well, as a result, he ceased to be an investor and he can't bring a claim, on your theory, for the Czech Republic ruining his business, contrary to what it promised to do in the treaty. That's the consequence, isn't it?
My lord, with respect, the starting point to that proposition is one that I would respectfully say is not a complete picture of what the treaty seeks to do. It is sometimes said that investment treaties are there to protect investments, and that is the full stop when it comes to articulating the object and purpose of the treaty. But as we saw yesterday, in the preamble right through to the protocol, the states to this treaty have only agreed to extend that type of protection to investments where there is investments by investors.
Well, that's a circular argument with respect. doesn't answer my lord's point. You're arguing from the position that you want to end up. But the $64,000 question is what's being protected, and in my lord's example there is no protection whatsoever, although on the face of it the treaty appears to afford it.
Well, in that example, my lady, the answer is not a difficult one for the investor if one approaches it from a purely commercial perspective.
Well, he hangs on to in order to be able to sue the Czech Republic for ruining his business, he needs to hang on to the asset.
My lady, I would approach it from the converse, which is that all the investor needs to do is send a letter consenting to arbitration. Indeed, there are plenty of investors who, when they make that initial investment in a host state, send that consent to arbitration on day one of the investment. So if there is a hint of a situation where a breach of the fair and equitable treatment is impairing an investment by an investor, the answer isn't to interpret the treaty by reference to a commercial instinct. The answer is to interpret the treaty by reference to its terms based on Article 31.1 of the Vienna Convention, aware that the practical answer to these commercial considerations is not a different interpretation, but rather the investor simply acting commercially. Indeed, it is entirely commonplace that as soon as there is even a hint of mistreatment for a foreign investor, that investor will consent to arbitration in a communication to the host state immediately. It is a standard form of interaction between investor and host state when the investor is covered by a treaty, for that investor in those communications to refer to protections under the treaty, to communicate if they feel that those protections have been breached, and to consent proactively and well in advance, rather than waiting for the investment to be destroyed and to run into the long grass.
But that rather reinforces my lord's point that the construction of the offer isn't serving the purpose in the preamble of creating and maintaining favourable conditions for investments by investors in the other territory, and promoting and protecting foreign investments. Because if the consent which the state is giving depends solely upon the happenstance of when the qualifying investor seeks to accept the offer, that's not a consideration which bears upon the purpose in the preamble.
But, my lord, I would agree that it is happenstance when an investor accepts the consent or the offer of arbitration. And with respect, that is why that type of analysis, driven by a commercial outlook, is not the correct approach. The paragraph from the preamble that your lordship just read out, creating favourable conditions for investment, has an important textual limitation in it, which is then repeated in virtually every article right through to the protocol. And that textual limitation is that it's only a protection for investments by investors. If that is not something that you have, if that is not something a claimant can satisfy, then the offer to arbitration does not extend to that. The object and purpose of the treaty is not to extend to investments that are not by investors. And if I can take a hypothetical that perhaps builds on what my Lord Justice Mayles says. If there is a situation, for example, where there is conduct by a state which is during the time that the investment is held, but then the investment is disposed of immediately after that conduct, and there is very little impairment by that conduct, it would be, in my submission, a very uncommercial, unworkable interpretation of this treaty to say that a claim can still be brought in 10 years, 20 years, 30 years from then. Rather, if that is the situation, that a claim is brought a significant period of time after, then the interpretation advanced by the Czech Republic, where there needs to be an investment by an investor, is a very sensible limitation.
But on your case, that could still happen. They could, at the moment they make the investment, they say we accept the offer in relation to this investment. They can still bring their claim 30 years later And on your case, there's no problem with that.
My lord, that would not be an answer to the question about investment by investors. That is an answer to the practical commercial consideration.
Yes, but you're saying, well, wouldn't it be odd if you could bring a claim 30 years later when you've only had a minor impairment? To which the answer is, you can do that on your case. All you need to have done is to accept the offer when you make the investment or at the moment that the conduct takes place, rather than doing it later.
And in those circumstances where the state has seen the offer accepted, then that does put a different gloss on that delay before the arbitration is ultimately commenced. But the notion that there is no acceptance of the offer, the state is not even aware of this investor because they may not have communicated with the state at all in the conduct of their investment. But then a very significant period of time later, the arbitration can begin, in my respectful submission, would fall well outside the object and purpose of the treaty, which says there must be an investment by an investor. And can I just make the point also?
I'm not sure, sorry to interrupt, I'm not sure how the day one acceptance works. So you have your investment, and the day that, or the day after you make your investment, you say we accept the offer to arbitrate. But at that stage, there's no dispute because everything's still going swimmingly. But some years later, there is misconduct in the terms of the treaty, failure of fair and equitable treatment, and the investor sells the assets because his business is not doing anything for him anymore, and then says, right, I want now to start an arbitration. And that's not materially different other than the fact that a formal letter has been sent. Is there jurisdiction then, or is it a standing issue, or what is it?
So in that situation, my lord, where there is no further communication, then the offer of arbitration would be accepted. So there would be perfected consent between the two parties. But then there would be a debate about whether or not the subsequent conduct would go to the merits or not. But that is obviously a different situation to the one that we have here.
So it makes all the difference that you send a purely formal letter on day one.
My lord, it makes a significant difference, yes. Now, the timing of it, by reference to the conduct that is then impugned, may well give rise to other issues. But in terms of whether or not there is an investment by an investor, that is a way in which that fact would be then relevant to that assessment. Now, that doesn't change that the substance of the objection for the date of commencement point or the post-dating conduct point would still remain. If one disposes of the investment, those objections would still likely be won by the state and are properly characterised as jurisdictional. But it would be a point for the investor to say, I did consent to this arbitration at a previous point in time.
And
So
you send your formal letter on day one, and then some years later you enter into a transaction which arguably means that you have disposed of your investment, but there's an argument the other way as well. And there is then misconduct by the state, and you seek to invoke an arbitration. The state says, well, you've sold your investment by the time I did anything objectionable. Is that a jurisdictional objection or a standing objection?
that is a jurisdictional objection, my lord. The post-dating objection would still exist in this situation, but it would simply be that the investor would be able to say that they consented to the arbitration before that conduct. What they will not be able to say is that I still have an investment by an investor at the date of that post-dating breach, as in post-dating the disposal of the
ultimately, consenting on day one doesn't make any difference.
In terms of the characterization of the objection, no, absolutely not. So the characterization issue is not affected by that. The reason we were discussing the communication of a consent to arbitrate by the investor was by looking back to the overall object and purpose of the treaty. And in my submission, that is not an object and purpose that is defined by reference to commercial reality. Rather, it is defined by reference to the starting point of there being no consent to arbitration for states under international law, and the consent to arbitration only being defined by the terms of the treaty. Now, that's not to say that consent to arbitrations are defined restrictively or expansively in international law. But when one is seeking a balanced interpretation of a provision like Article 9, it is a relevant consideration that the starting point is no consent. And so one looks carefully at the terms of that provision, carefully at the terms of the scope of the treaty, like Article 2, and indeed the preamble, to see what the delimitation of the consent to arbitrate is. And in my submission, once one moves away from those commercial discussions that we've been having and focuses on the interpretation of the treaty in light of that starting point, then it is clear in my submission that one needs to have an investment by an investor. And can I just make the point, my lords, my lady, by reference to the position in relation to Diag Human. Now, this is the point that Mr. Dunning is going to take up, so I'll only be brief. But it is common ground, my lords, my lady, that the transfer of the asset gives rise to an objection of a jurisdictional nature. That was the finding by Mr. Justice Foxton below, I believe, in paragraph 1.5. Pardon me, it was common ground, and it was reflected in paragraph 153 of the judgment. And 154, I'm grateful to Mr. Dunning. And that point is res judicata. So in those circumstances, that is a further indication that the interpretation advanced by the Czech Republic is the correct interpretation. It was common ground in the Diag Human side of the case, and recorded by his lordship below. My lords, my lady, can I come then to the second point relating to the substance of the question that my Lord Justice Popplewell posed yesterday and that we have been discussing. And that point is that the authorities confirm that the Czech Republic's approach is correct. Now, just to recall the initial point that we started with this morning, this is not the point that this court needs to decide, and is to be decided on the facts. But it is relevant to see how this case law situates the point for the purposes of characterization. Can we please go, operator, to Alcor at LA/24. The court will recall that this is the tribunal in which Sir Christopher Greenwood was the presiding arbitrator. Can we please go to page 2? And one can see there the table of contents, and section 4B shows the breaches in issue.
Just give me the bonkers.
Yes, it's LA24, and I believe in the hard copy bundle, that is volume 6.
Just so you know, this is fine because we've got this in hard copy. I've got 3 screens in addition to my own laptop, and on none of them is the document that is being put up by the operator. So if we get to a stage at which we're reliant on the electronic bundle, I shall be in difficulty.
I'm grateful, my lord. Hopefully one of the screens can be connected during the break.
Thank you.
If the court has LA24 at hard copy bundle 6, page 2 is the table of contents, and section 4B shows the breaches in issue in that case. Now, there is no expropriation claim in Alcor. However, this tribunal did consider how the principles that we have been discussing would apply to an expropriation claim. Let's go to where the tribunal discusses the legal effect of the disposal of the investment in this case that we touched on yesterday. That starts at paragraph 255 at LA-24-70.
It starts at paragraph 246.
We will come back to paragraph 246, my lady, but you're right that it does the overall section starts there, but the subsection in this section, which deals with the effect of the sale of the investment, begins at heading 3 at paragraph 255. You can see what has come before prompts the tribunal to say that leads to the question which lies at the heart of the present case, namely whether a claimant which had made a qualifying investment can bring itself within the jurisdiction of a tribunal under Article 9 of the BIT if it no longer owns that investment at the date of commencing proceedings. Since the critical date is the date of the commencement of the arbitration proceedings, it follows that the CSOB tribunal held that sale or other divestment of an investment after the date of commencement of the arbitration is irrelevant for the purpose of determining jurisdiction. What matters for the present case is the effect of sale or other divestment prior to the date of commencing the proceedings. Now, the conclusion on this point is in paragraphs 256 to 257, just below. And I am just going to walk through those. You can see in paragraph 256 that the tribunal starts by saying the claimant argues that Article 9 contains no requirement that the claimant must be an investor at the time that it commences arbitration proceedings. The tribunal says Article 9 must be read together with the definitions in Article 1, and it refers to the language that is contained in those definitions and distinguishes that from the language in NAFTA, which was at issue in Monday. This is the point I took the court to yesterday about how NAFTA contains the language in its definitional provision of an investor has made an investment in that past tense. But it's the final sentence in this paragraph that I draw to the court's attention. Nevertheless, the tribunal considers that the more natural reading of the relevant provisions of the treaty is that it is not enough that a person made an investment at some point in the past. To qualify as an investor, that person must ordinarily continue to hold that investment at the time that it seeks to take advantage of Article 9. The tribunal continues, the tribunal does not accept the claimant's contention that it would be illogical to the point of absurdity to hold that jurisdiction did not exist if a party which had made a qualifying investment had ceased to own it before that party commenced arbitration proceedings. On the contrary, the tribunal considers that in such a case, the party in question would normally no longer be an investor at the date when it commenced arbitration proceedings and would therefore be incapable of accepting the offer to arbitrate made in the investment treaty. What would be illogical in the tribunal's view would be to read Article 9 as though it treated a person as an investor, even if that person had long since ceased to hold the investment in question. So my submission, my lords, my lady, as reflected here, a tribunal will treat it as a jurisdictional issue whether it is able to decide a dispute arising from whether there was an investment at the relevant time. Now, the relevant time in our court, I accept, was the date of commencement, whereas as we have discussed, it is also an issue in this case about post-dating conduct, i.e. where the alleged breaches post-dated the disposal of the investment.
Was it ever suggested in our court that it wasn't a jurisdictional issue?
My lady, I would have to check the submissions by the claimant in that case.
It doesn't look as if it was.
I don't recall that it was. But in circumstances where the tribunal is articulating in some detail the principles which delineate the offer of arbitration in the treaty, and when an investor will have an investment that is falling within the scope of that offer of arbitration, I respectfully suggest that it is still persuasive authority for the tribunal to look at these points.
It looks, tell me if I'm wrong, it looks as though from the way in which the terms in which Para 257 and 256 are couched and from the preceding section, as if they're treating the relevant date as the date of the commencement of proceedings as such, not the date at which the Article 9 offer is accepted.
And my lord, that is correct, and the reason why that's important.
How can that be logical?
Well, the reason why it's important is that, or logical, is that this tribunal is considering whether the offer to arbitration can be accepted. So the idea of the date point is relevant because of the general principle that jurisdiction is determined as at the date of the commencement of the arbitration. But what is
Surely jurisdiction is determined at the date of the acceptance of the offer. And that's, as an English lawyer, that's rather what I would. Well, I'm not sure it is necessarily the same thing. It may be the same thing in some cases, but the way this tribunal is addressing the question seems to be starting from some a priori principle of international law, 251, that it's the commencement of proceedings that matters, and then expressing itself in terms of having to be an investor at the commencement of proceedings.
So, my lord, I accept that there are times where those types of principles can merge together, but it is correct to say that the acceptance of the offer to arbitrate is the commencement of the proceedings.
Sometimes, but not always.
In this case, it looks as if it was.
Well, in this, I'm grateful to my lady. In this case, it certainly was, and that may frame why the tribunal in this case was speaking in these terms. But the important point here is that ultimately, the tribunal is considering the existence and the scope of the offer of arbitration. And an objection that this investment by this investor in our court did not fall within the scope of that offer of arbitration. And that point is obviously not on all fours with the position in this case, but is characterised properly as jurisdictional in a section 30 sense. So the assistance that one derives from our court is that even though the objection might be slightly different, or framed slightly differently, or put on slightly different facts in that case, it is still an objection about the existence and scope of the offer to arbitration and what limitations apply to it. And that is characterised clearly as a jurisdictional point. I've used the word that these cases help situate the Czech Republic's point on this appeal. And I use the word situate because I accept they are not on all fours with the facts of this case. But given that these cases we're discussing all do talk about whether the offer to arbitration exists and if it does, what its scope, and treats that as jurisdictional, in my submission, that is an important situation of the Czech Republic's point.
As you say, it does
jurisdictional
depend on how you interpret the offer to arbitrate. But if you interpret the offer to arbitrate as being made to somebody who, after the date of the treaty, makes a qualifying investment in the Czech Republic, then at the date of commencement of arbitrations, even if that person has in the meanwhile disposed of their asset, they do satisfy that requirement because they still are somebody who has made a qualifying investment after the date of the treaty.
So my lord, yes, but that goes to the substance of the objection. What is implicit within what your lordship is saying, I say with respect, is that that is a jurisdictional question. And so the characterisation issue that your lordship is deciding is implicit within that proposition that your lordship just put to me. And the answer to that, of course, is that is characterised as jurisdiction.
Notice that the Alcor decision was one which expressly refused to follow Daimler.
Indeed, my lady, and it may well be that in your notional spare time, a full reading of Alcor will be beneficial. We won't have time to go through all the passages in it, but it did look at Daimler and say that that is not the correct approach, and it favoured cases like Avon and IC Power. And in my respectful submission, this is the persuasive authority. It is presided over by among the most eminent international lawyers, and its articulation of principle, in my respectful submission, is entirely consistent and persuasive throughout. But indeed, my lady, I don't need to persuade the court that Alcor has been correctly decided on the substance. All I need to persuade the court is of the lower threshold that Alcor was right to treat this issue about the existence and scope of the consent to arbitrate as a jurisdictional one. And in my submission, Alcor clearly does that and is clearly correct to do that. And that is why that characterisation, as I submitted, was entirely correctly baked into the question of my Lord Justice Mayor. Can I come to a related point that we touched on yesterday and have touched on a little bit already this morning? And it's the expropriation point. It has been put to me entirely properly, of course, that this is the point that tests the proposition that I have been relying on. And I indicated yesterday that the expropriation point may well be treated differently, may well be a special circumstance. And it has been held by various tribunals that it is, and that is achieved by way of reading in an exception that allows a claimant to accept an offer to arbitrate in certain limited circumstances, such as expropriation. I'll stay with our core for now, if I may. Can we please turn back to paragraph 119, which is at LA-24-31. It's page 27 of the hard copy of the award. It starts on page 26. And there one can see that the respondent state is putting its jurisdictional objection on the basis of the claimant having voluntarily disposed of its asset, like we have in our case. The respondent objects to the tribunal's jurisdiction on the grounds that the claimant was not an investor within the meaning of Article 1.2. The respondent does not contest that the claimant is a juridical person recognised as such under the law of the UAE. According to the respondent, however, the claimant had relinquished any standing it may have as an investor by voluntarily disposing of its shares in Alcord CZ in the sale to Mizar on 24 February 2016, well before serving its notice of arbitration. Now, the tribunal goes on to consider the effect of this at paragraph 121 down the page, and that's where the Czech Republic submitted that there were only narrow exceptions to the rule that a claimant must have been an investor at the commencement of the arbitration. If I can pick up in the 7th line right towards the bottom of the page, according to the respondent, the special circumstances contemplated by the Avon Tribunal are limited to the involuntary loss of control over the investment through the actions of a party, such as the respondent state, other than the claimant. For example, where the investment has been expropriated or the investor has been coerced into a forced sale.
What is the juridical basis for this supposed exception?
My lord, my lady, when you refer to the juridical basis, you mean
Is it a matter of construction?
Is it a
Because
matter of
from an English
construction?
law point of view, we would tend to approach the exercise that we're addressing here under the nature and scope of the offer under Article 9 as being a question of construction and what is meant by investor. And it's rather difficult to treat the idea that the exceptional circumstances which depend upon the nature of the breach as affecting the construction question. Now, that you may say that's completely the wrong way to approach it, but I think that's what's behind my lady's question. Just before you answer it, can I just clear my mind on what law we're dealing with? The arbitration agreement, is it common ground, is governed by international law, not any national system of law, and that remains the case, notwithstanding that the curial law of the arbitration is English law as a result of choice of the seat. So in classic English taxonomy, curial law, English law, but proper law of the arbitration agreement by which it has to be interpreted is international law. Is that common ground?
It's correct. It's not a point that has been pleaded as common ground, but I'll leave my learned friend to make submissions on it, but I would be surprised if any applicable law other than international law applied to the interpretation of the treaty.
So going back to my lady's question, what principle of international law allows one to look at the interpretation of Article 9 as depending not upon the meaning of the word investor, but upon the nature of the breach in each individual case?
The principle, my lord, my lady, is the one that I mentioned yesterday, which I can summarise as good faith. The court will recall that in Article 31(1) of the Vienna Convention, a treaty must be interpreted in good faith, and in Article 26 of the Vienna Convention, it must be performed in good faith. So in circumstances where the disposal of the asset is done through a forced sale or an outright dispossession by the host state, that is obviously party to the treaty, then there is a good faith limitation on both the interpretation and the performance of the treaty that the state cannot then say, in reliance on its own conduct, that you do not have protection of the treaty.
It operates in English terms rather like an estoppel.
Yes, my lady, and that is a helpful analogy. And while the test for estoppel in international law is set out in cases like Cameroon and Nigeria, and is not something the parties have pleaded in this case, it is, at a broad level, a helpful analogy. Indeed, other principles that reflect that principle of good faith under international law are also of assistance. The principle of ex turpi causa, where one cannot rely on one's own misconduct to justify a wrongdoing, is also a limitation on the interpretation and application or performance of the treaty. Ex turpi causa has been recently considered by the International Court of Justice in the Judgement case, which I'm afraid we don't have on record. But these types of good faith principles have variants throughout international law, but ultimately do trace back, in my submission, to Article 31(1) for the interpretation point and Article 26 for the performance point. I should note that Mr. Dunning on the second appeal will be making submissions on good faith in connection with Article 31(1), so the court will hear further detail on that point.
So you would say the principle of good faith, however you characterise it, operates as a means of precluding the state in that hypothetical situation from raising a jurisdictional objection as opposed to substantively precluding them from making an argument. That's your point. They can't ask for the treaty to be properly employed or properly applied. The scope of the treaty is somehow enlarged.
Yes, my lady. A good faith interpretation of the scope of the treaty in Article 2 and the offer for arbitration in Article 9 would have that result. And that,
even though that person is no longer an investor. He's no longer an investor, he doesn't have an investment, but you interpret the treaty as saying he can nevertheless accept the offer to arbitrate because of good faith.
Yes, my lady. And so while the treaty requires that there is an investment by an investor, in this type of limited or special circumstance, then this type of juridical point operates so as to avoid the situation where the state benefits from its own wrongdoing. And indeed, Alcor continues to discuss this point so that one can see, in practical terms, how these special circumstances do operate as an exception, which in my submission are grounded as a matter of international law in good faith. We have looked at paragraph 121, I believe, and if we can then go to the legal effect of what we saw in paragraph 119 and 121, that's at paragraph 273, which is at page 30. No, pardon me, I have the wrong reference. Paragraph 273, please, operator, if we could bring that up. I'm grateful, operator, for the transcript. That is page 75 in the opus, page 71 of the hard copy. And I'm afraid I am going to work through a handful of paragraphs here, my lords, my lady. 273. The tribunal, however, prefers the analysis in Avon, which confirms the conclusion at which the tribunal already arrived, namely that, unless there are special circumstances, or the treaty otherwise provides, it is a requirement of jurisdiction that the claimant still hold the investment at the date of commencing proceedings. The rest of that paragraph talks about the Avon case and compares it to the facts of this case, of the Alcor case. Moving on to 274, it continues, the tribunal accepts that there are cases in which an investor has ceased to own the investment before the commencement of arbitration proceedings, but nevertheless retains capacity to accept the offer of arbitration in an investment treaty. These are the special circumstances to which the Avon Tribunal referred. I pause there to interpolate that the tribunal is plainly using the term jurisdiction here to refer to jurisdiction in the Section 30 sense. It's talking about the capacity to accept an offer to arbitrate. So for the purpose of this appeal and what the court needs to decide, the characterization issue, it is clear that the matter is jurisdictional. Just to continue at 275, that raises the question, what are special circumstances for these purposes? The tribunal considers that these are necessarily fact-specific and that it's neither possible nor desirable to attempt to create a comprehensive list of what might constitute special circumstances. It is, however, appropriate to look at what has been regarded as special circumstances in other awards. Leaving aside the reference...
So if a tribunal decides that there are special circumstances, or for that matter, that there aren't special circumstances, is that a decision which goes to their substantive jurisdiction and can be challenged in an English court?
My lord, yes, because that would be a decision relating to the proper delineation of the scope to arbitrate in the treaty based on the terms in the disputes clause and the scope of application clause. So that would be part of the jurisdictional findings of the tribunal.
Though it's rather surprising, in a way, if someone undoubtedly has been a qualifying investor, and the question whether they can bring a claim is fact-specific and it's impossible to create a comprehensive list, to think that that's something which the court is supposed to decide rather than the arbitrators.
My lord, that concern about whether or not a jurisdictional point will have a factual element to it is of course a concern that has occupied English courts previously, like in Tatneft and indeed before Mr. Justice Foxton below. So I accept that the need to consider evidence and facts does make the jurisdictional objection more meaty in any review court process, but that doesn't change the characterization of the objection as jurisdictional. Indeed, in this very case, of course, as the court will know, there was significant evidence, including expert evidence filed below, in order to determine an objection which his lordship has now held and is raised judicata and not challenged on appeal is jurisdictional. I'm referring, of course, to the Diag Human point that Mr. Dunning will take up. So while that point is often a starting point to test the mind as to whether an objection is jurisdictional or admissibility, with respect, my lord, it is not a clinching argument, and there are plenty of jurisdictional arguments which do require that type of investigation into the facts. One might even hazard the criticism of being described as seeking investment treaty exceptionalism to say that there are objections in the context of investment treaty arbitration that will more naturally lend themselves to a fact-intensive exercise, but are clearly jurisdictional. And indeed, as I'm helpfully assisted, this is what Parliament has decided is the correct approach by not differentiating between investment treaty arbitration and commercial arbitration for the purposes of Section 67 and indeed Section 73. Just to give an example of a type of objection that one sees quite regularly in investment arbitration, which is treated as jurisdictional, that would be where the investment is procured by bribery or corruption, a point that is treated as jurisdictional but would naturally involve an investigation into the facts concerning that allegation, that objection, in order to determine whether or not it did occur, and that deprives the tribunal of jurisdiction. Somewhat long-winded answer to your question, my lord, but hopefully of assistance. Thank you. 276 on Avon, which remains on the screen, of Alcor, which remains on the screen, continues by providing core examples of what counts for special circumstances. picking up at the second line, the most obvious example is where the investment has been expropriated. In such a case, the loss of ownership is not voluntary, but is the effect of the very breach of the treaty which the claimant seeks to challenge. I interpolate that that's echoes of the good faith point that I was making earlier. I continue, to prevent a claimant from bringing a case in such circumstances would be to allow the defendant state to profit from its own wrong and frustrate a core object of the treaty. 277 continues, the same logic applies where an investor is forced to sell the investment. As, for example, many Jewish owners were forced to sell their property by Nazi authorities between 1933 and 1945. The tribunal accepts that the sale would not preclude the investor from pursuing a claim. So those are the types of special circumstances, very limited, very exceptional, that operate in the way that the Alcor Tribunal articulates the proposition. I've gone through those paragraphs to help adumbrate the nature of the objection that gives rise to the jurisdictional complaint. But of course, as I indicated earlier, this court does not need to take a view on the substance of that objection. I know I'm sounding a little bit like a broken record, but the reason we are going to these cases that are not exactly on all fours with the current case is to situate the current case. We are situating it as one which gives rise to a jurisdictional objection because it concerns the existence and scope of the consent to arbitrate. These cases do too, even if the principle or the facts they are considering are slightly different.
But the thrust of the argument seems here to be, is coupled with what you say is the basis for it. Whether special circumstances exist, which is a jurisdictional question, will depend upon a factual inquiry into whether the state has acted in good faith in relation to the divestment of assets. That may not be expropriation, it may be all sorts of other things. We get the example of being forced into submission if that's what can potentially be regarded as coercive and so on. And that does involve, doesn't it, what you characterise as a jurisdictional question, not merely being dependent on the facts, but being dependent on whether or not there's a breach of the putative treaty obligations, which is what one imagines is very much what is intended to be within the scope of what it is for the tribunal to decide, rather than a national court.
My Lord, I pause in relation to that because I think there are two responses. The first is to clarify a point and then to engage with the substance of it. The point to clarify is that there would not need to be any analysis of whether an expropriation was done in good faith. The expropriation, of course, or a dispossession, as the treaty language sometimes is done according to the test for expropriation in the treaty.
No, but one might have circumstances, sorry to interrupt you, one might have circumstances in which the actions of the state have an effect on what is said to be a divestment, which don't come within Article 6 at all,
yes.
But are breach of the obligations of good faith.
As is envisaged in this very passage in Alcor, because the starving into submission argument was rejected on the facts, but funnily enough, it was the tribunal that decided whether or not it was a case of starving into submission. And on your analysis, it wouldn't be for the tribunal at all, it would be for the court.
Well, my lady, my lord, I embrace that situation for the same reason that I answered to His Lordship, Lord Justice Males. And the reason I embrace that is that there isn't a limitation when it comes to the Section 67 jurisdiction of the court, that it cannot investigate the facts or the evidence at all. Indeed, one regularly sees objections which are jurisdictional that come before the court, which do require an investigation into the facts.
I understand that, but what I was putting to you is that what this seems to envisage is that in order to determine jurisdiction, you need to look at the facts as to whether or not there has been a substantive breach of the treaty obligations, the putative analysis that the treaty obligations apply, which is slightly different and is something which it normally seems to point towards that being a matter of substance for the tribunal, not jurisdiction for a reviewing court.
Of course, when your lordship uses the word normally, there is not a bright line test in that regard, and I would submit that in circumstances where the question is whether or not a dispossession or a forced sale has occurred, then the facts would be relatively limited and relatively confined in that situation. But what's important, I think, to bear in mind is that often points will go both to jurisdiction and substance. It's entirely common in commercial and investment arbitration for that to be the position. A question which is regularly asked in investment arbitration is whether there is an investment at all. That, of course, has...
That is true, of course. Everyone sees it commonly in relation to whether a contract was originally made or whatever.
Exactly.
But that is not the common situation if the overlap is in relation to whether there is a breach of the putative obligations. That isn't the kind of overlap that normally arises, is it?
Sorry, my lord.
It doesn't normally get an overlap between a jurisdictional, a matter that goes to jurisdiction, and a matter which is limited to whether there is a breach of the obligations.
With respect, my lord, there is certainly a significant body of cases where there is no overlap. But my submission would be that the alternative, where there is overlap, is not as unusual or a minority case as one would imagine. That's certainly the case in investment arbitration, where concepts of the existence and nature or scope of the investment clearly have a jurisdictional impact, then clearly have a merits impact as well. And I'm reminded, I'm grateful to Mr. Dunning, that prime trade itself was a situation where a Section 67 jurisdiction was invoked for the court, but it turned on a question of facts. Now, Mr. Dunning, I know, will be picking up prime trade further and has the advantage of being involved in that case. But one can see plenty of situations where that overlap that you refer to, my lord, does exist, but does not prevent the objection from being characterised as jurisdictional and the Section 67 powers of the court being invoked.
You may very well be right. I quite understand that there's an overlap between factual disputes. But I'm just impressionistically unaware of cases where that could be said of where the substantive dispute is as to whether there's a breach of the putative obligations as opposed to other aspects as to whether a contract was made, whether it's vitiated by lack of consent.
And whether the contract was made is, of course, the first type of objection that one's mind goes to when considering commercial arbitration, where the objection could be both jurisdictional, but then also relating to the facts.
The point I'm putting to you is that one can't draw an analogy between that and the idea of specialist exceptions being jurisdictional. If the specialist exceptions depend upon putative breaches of the treaty obligations of good faith.
To an extent, my lord, because ultimately those putative breaches of the treaty will still come down to a question of fact, usually quite a limited scope of fact when it's a direct expropriation or a forced sale. And those facts then will be able to be pleaded before the court and the subject of evidence in the usual way that one sees in the current Section 67 jurisdiction of the court. Indeed, in my submission, one only needs look so far as the proceedings below before Mr. Justice Foxton to see exactly that type of situation. Very significant evidence with specialist pleadings on Liechtenstein law were put forward by the parties before his lordship in order to have him determine a question that he ultimately held and is res judicata as being jurisdictional. So in those circumstances, I fully accept the point that my Lord Justice Mayles initiated, that where there is an investigation into facts, a question does occur in one's mind as to whether that militates against the characterisation as jurisdictional. But in my submission, that militation against that characterisation is not so significant as to overcome the nature of the objection being jurisdictional. Indeed, for the reasons that were spelled out in our call, in the context of an investment treaty arbitration, it is, in my submission, quite clear that this is treated as a jurisdictional issue. So in those circumstances, we say that Alcor, clearly treating the matter as jurisdictional, and doing so pursuant to persuasive reasoning, situates the point that the Czech Republic advances on appeal and situates it as a jurisdictional point.
And sorry to keep interrupting, but insofar as one can identify what international law principle was being relied on here, is one right to identify it as at the end of 376, an ex terpi causa shouldn't allow a state to profit from its own wrong and thereby frustrate a core object of the treaty. That.
Yes.
So far as this tribunal was concerned anyway, was the international law principle that might
Yes, my lord.
justify the exceptionalism.
And even if the tribunal did not say, in rather abecedarian terms for undergraduate studies, this comes from Article 31.1 of the Vienna Convention and Article 26 and the ex terpi causa principle, in my submission at the end of 276, it is very clear that it is relying on that good faith nature of the point. And so in those circumstances, when one looks at Article 9 and Article 2 in the way that we have done so, one looks at the reasoning in Alcor. In my submission, there's not a difficulty in reaching the conclusion that this type of objection about the extent and the scope of the consent to arbitrate is jurisdictional. So my lords, my lady, the submissions I've been making have been following on from our engagement yesterday. And I will just wrap up the submissions this morning to try and capture what I suggest is the core point, which militates in favour of the finding that the objection advanced by the Czech Republic is jurisdictional. When one steps back and looks at the Stava June 2011 objection, that is ultimately an objection about the existence and scope of the consent to arbitrate. While it is relatively rare to find investment arbitrations that are on all fours with the facts of this case, there are other types of objections, like those we have been discussing, which concern the existence of the consent to arbitrate or the scope of that consent to arbitrate in the context of a disposal of the asset. And those cases all point to the objection being characterised as jurisdictional. I fully accept that there is no stare decisis. I fully accept that some of those awards can be said not to have had full argument on parts of what I have been relying on. But when one looks at the terms of the treaty, Article 9, Article 2 in particular, and one then carries that through to the Phoenix case that we discussed yesterday and to Vucklinghaus, which I'll come to in a moment, and one then situates that principle in the context of cases like Alcor and Aven and others that we have been discussing, the point is a jurisdictional one in the Section 30 sense. It's jurisdictional in those cases. In my respectful submission, it ought to be jurisdictional in this otherwise closely aligned, if not exactly the same case. In my submission, it would be unusual for points around the disposal of an asset and its impact on the existence and scope for consent to arbitrate in those cases to be regarded as jurisdictional and therefore subject to the court's review. But then in the present case before the court, in relation to the Stava June 2011 objection, for the opposite conclusion to be reached. For that to be regarded as a question of admissibility, but everything else around it to be regarded as a question of jurisdiction, would, in my respectful submission, be an unusual outcome. I have sought to take the court through the reasons why, both on the treaty terms and the cases, it is properly characterised as jurisdictional. But this idea of an island of a proposition where just this type of case, just the Stava June 2011 point, is treated as admissibility, but every other point dealing with disposal of assets, which goes to the existence and the scope of the consent to arbitrate, is jurisdictional, would in my submission be an outcome that is not principled. My lords, my lady, That is what I wish to say, following on from the starter question from 10 that my Lord Justice Popplewell posed to me yesterday. I know that our discussion has been roving somewhat, and I think that that will save time as I move on with my submissions. But move on I do now wish to do, and I wish to come to the second case, which we say is in the category of circumstances the court is currently presented with. I discussed with the court yesterday Phoenix and Czech Republic, but I don't propose to go back to that point, though I'll see what my learned friend has to say, and I may need to reply. Wukklinghouse and Czech Republic is the second case dealing with this category of objection. The facts have been summarised in my skeleton. And I don't know if the court has hard copies of the skeleton. I don't actually have a bundle reference, an opus bundle reference. CB3. I'm very grateful to Lord Verderame. CB3 is the reference to my skeleton. It's paragraph 53 in that, please, operator. If I just go to this as an easy summary of the facts rather than turning through many pages of the award.
Just give me the paragraph number again.
Paragraph 53 of the skeleton, my lord.
Page 18.
Page 18. I'm grateful. There the facts are summarised beginning in the third line. The claim related to a right to repayment of loans made to a golf resorts project corporate vehicle. The entity to be repaid was MFTK. It would be owned by MFTE, which was owned by MFTVA. 76.66% of MFTVA was owned by Mr. Wukklinghouse, who is the claimant. But on 27 December 2000, MFTE transferred its interest in MFTK to a third party, and on 8 March 2001, MFTVA divested its ownership in MFTE. By 8 March 2001, the claimant no longer indirectly owned MFTK. I hope that's a helpful short summary of the facts, which allows us now to go to the award to see how the tribunal dealt with that as a legal matter. The award is at LA 10, which is in hard bundle 2. If we start by turning over the page to the table of contents, one can see towards the bottom of the page that the relevant legal analysis in relation to the facts we have summarised is in section I. That section begins on page 4, page 34. That's where section I begins, and it begins with some introductory remarks over the first few pages. We can turn to the first subsection that we saw in the table of contents, which is on page 40, please, operator. One can see at the top, is there an investment? Now, in my submission, there is no doubt that that is a jurisdictional point, the existence of an investment. Now, paragraph 136 contains the claimant's submissions. The claimant is designated as PV in the award. And it's his submissions that he is an investor and had an investment. One then goes on to the next paragraph and we see the jurisdictional point in dispute. Whilst it is common ground that PV is an investor within the terms of the treaty, the extent of his investment is in dispute. The Czech Republic did not challenge PV's 50% shareholding in Comfort. However, it maintained that the tribunal had no jurisdiction over PV's claim to repayment. First, because PV had failed to demonstrate that he had a legal or beneficial interest in MFTK at the time of the alleged breaches of the treaty. And then it goes on with a point that's not currently relevant. So this is the host state's position, clearly presenting the point about the claimant's ownership of the investment at the time of breach as a jurisdictional one. In what follows from this paragraph onwards, the tribunal reviews the various transactions that led to the claimant's disposal of the asset. I will come back to some of this, but having done so, the tribunal reaches its conclusion at paragraph 165. Operator, could we please turn to page 48? There, at the top of the page, the conclusion is that PV retained no legal or beneficial ownership interest in MFTK after 8 March 2001, some 7 months prior to the bankruptcy of Comfort, and any alleged wrongdoing by the Czech Republic. Accordingly, the tribunal holds it has no jurisdiction to hear PV's claims in respect of receivables owed to MFTK by Comfort.
I just note at page 40, paragraph 138, where the discussion of the dealings in the shares begins, it's all under the heading of PV's standing. So I don't know whether this is one of those cases where really there was no need to distinguish between standing and jurisdiction. Anyway, for what it's worth, the heading is there.
My lord has anticipated the very next point that I was coming to. What I wish to do by starting with the paragraphs I have done is to show that the characterization of the objection by the host state and the conclusion by the tribunal regard it as a jurisdictional point. And that makes sense when the first heading is there an investment? So in those circumstances, I suggest that the proper characterization is as exactly reflected in the conclusion of the tribunal, is of the objection as a jurisdictional one. Now, my lord has picked up on the point on which my learned friends rely with quite some weight. They say that this award equivocates in its characterization of the issue as jurisdiction. And that is based, my lord, on the subheading that your lordship has referred to on page 40, where it says PV standing. Operator, perhaps we can put up page 40 on the screen. I want to make 2 points about this observation, my lord. In my submission, to point to this subheading and say that is enough to muddy the waters around the characterization of this as jurisdiction is a weak basis on which to say the point is not jurisdictional. It's simply not enough when the question being asked is there an investment? And the tribunal concludes in relation to that issue squarely as a matter of jurisdiction. But then if one looks at the paragraphs below that subheading of PV standing, one sees what the tribunal is doing in that regard. Paragraphs 138 to 142 set out the facts of the assignment of the receivables and the change in ownership of MFTK. The court can read that for itself, either now or later. But I would like to pick up the point at paragraph 142 over the page. There, the host state's submission, the Czech Republic, is recorded again, starting at the end of the third line. Thus contended the Czech Republic, PV had no legal ownership interest in the entity to which all receivables from Comfort were owed. That is the very same point that the tribunal had just recorded a couple of paragraphs earlier in paragraph 137 as a jurisdictional objection. It's the same point that the tribunal then determines in paragraph 165 as a jurisdictional objection. Jurisdictional, of course, in the section 30 sense, because it is going to the square issue of is there an investment, which is the starting heading for this section. One then reads down into paragraph 143, that records the claimant's submission that the various agreements he entered into affected that conclusion. In my submission, that is not enough to say the award is equivocating as a matter of characterization of this objection. what appears to have happened in this case is that the claimant made some submission that related to his connection with the investment in light of those transaction agreements. And it may well be that this was loosely called standing in the transaction. But given the clarity of the conclusion, that takes my learned friends nowhere. This award in my submission, supplementing themes, is quite clear that the issue is jurisdictional, i.e. the very issue relating to the post-dating conduct. If the conduct impugned post-dates the disposal of the asset by the claimant, then the tribunal has no jurisdiction. That is the proper characterization of the point. The second point I wish to make in relation to this reliance by my learned friends on that heading is that it is not a safe inference when dealing with international law tribunals to say that a reference to standing must be a reference to admissibility. It is the case that standing, when that term is used in international law tribunals, can have the meaning of a jurisdictional objection. This may well tie into the practical observation that my Lord Justice Popplewell made yesterday about how the practical consequences of using a label slightly loosely or incorrectly in the context of an investment arbitration are not immediate and apparent to the arbitrators, but they do have implications if there is loose language in court proceedings. But that practical reality does mean that international law tribunals will sometimes use the word standing in connection with a jurisdictional issue, which is why I say it's not a safe inference that when one sees the word standing in these awards, that automatically means admissibility in the way that my learned friends rely on.
But not you say vice versa.
Indeed, my
When they
lord.
say jurisdiction, we can be confident they mean jurisdiction, not admissibility.
Indeed, my lord, when the term jurisdiction is used, that is typically done with greater certainty and clarity. And the reason for that, my lord, is that it is very common, certainly in investment arbitration, but also in other international legal fora, for the scope and the existence of the consent to that jurisdiction to be interpreted and analysed by that tribunal or that court. And where an international law tribunal or court is analysing the existence or scope of a consent to jurisdiction, a consent to arbitrate, or a compromissory clause in the International Court of Justice, that is a jurisdictional issue. In my respectful submission, it would be beyond argument that that type of objection is a jurisdictional objection for Section 30 purposes. So that's why it is not a two-way street, if I can paraphrase your lordship's observation. On the way in which standing ought not to be seen as immediately connoting an admissibility objection, I do want to come back to Alcor. I appreciate that I'm coming back to Alcor a number of times in my submissions, but the reasons for that are partly that it is the most recent case dealing with the issue it considers. It is written by a very eminent tribunal, and it reviews the previous case law and gives a view on cases like Daimler and Avon and so on. Operator, can we put up Alcor at LA 24, which is in Hard Bundle Volume 6, for those using Hard Bundle. And operator, can we please go to page 68? As one can see at the top, this is where the tribunal considers whether the claimant was an investor at the relevant time. We go over the page now, please, to page 69. Which I believe is page 65 in the hard copy. does the court have?
Page 65 of the bundle, page 61 of the award, which
I'm grateful. Lovely. Oh, no, so pardon me, it's page 69 opus reference, so page 69 of the electronic bundle.
I see, 65 of the award. Right,
Yes.
and then paragraph.
So starting at heading 2 on page 69, this is where the tribunal considers the date at which jurisdiction must exist. Paragraph 251, it begins, the tribunal considers that it is a general principle of international law that the date at which the requirements for the jurisdiction of an international court or tribunal must be established is the date at which proceedings are commenced. That approach has been confirmed by other investment arbitration tribunals, whose decisions, though not binding on the present tribunal, are nonetheless entitled to respect insofar as their reasoning is persuasive. The tribunal finds the reasoning of the tribunal in CSOB persuasive when that tribunal said, it is generally recognised that the determination whether a party has standing in an international judicial forum for purposes of jurisdiction to institute proceedings is made by reference to the date on which such proceedings are deemed to have been instituted. Since the claimant instituted these proceedings prior to the time when the two assignments were concluded, it follows that the tribunal has jurisdiction to hear this case, regardless of the legal effect, if any, the assignments might have had on the claimant's standing, had they preceded the filing of the case. So plainly, the concept of standing is not one that can only have an effect on the admissibility of a claim under international law. A very experienced tribunal here is explaining that the determination of whether a party has standing has effects for the purposes of jurisdiction. It is wrong, in my respectful submission, to say standing automatically equates to admissibility when an objection is taken in relation to it. And Alcor, of course, considered the position in respect of the situation that arose in Daimler as well, as my lady observed earlier. It regarded Daimler as not to be preferred in terms of the analysis to be followed, instead preferring Avon and CSOB. But importantly, it still regarded the issue as jurisdictional. So even though one can trace the interesting debate that tribunals have around this issue of the scope and the existence of the consent to arbitrate in cases involving a disposal of an asset, the treatment of that objection for the characterization question is jurisdictional. Paragraph 255 over the page is helpful in this regard. There, the tribunal continued. That leads to the question which lies at the heart of the present case, namely whether a claimant which had made a qualifying investment can bring itself within the jurisdiction of the tribunal under Article 9 of the BIT, if it no longer owns that investment at the date of commencing proceedings. Clearly treating the post-dating point, so alleged breaches after the disposal of investment, as a jurisdictional question, including with reference to Article 9, which is obviously the existence and the scope of the consent to arbitrate. On the only issue that this court needs to reach a decision on in this appeal, the characterization issue, I respectfully submit that the authorities we have been reviewing are quite clear and consistent in treating this as jurisdiction. Having a heading saying PV standing in Vauclinghouse is not the barrier to this being treated as a jurisdictional objection that my learned friends suggest that it is. The language of the treaty, I suggest, is very clear, and then that carries through to the clear position of the authorities. The last point I just want to take in relation to Alcor before moving on is over the page at paragraph 257. This is the paragraph that I read before, so I won't read it again for the purpose of the transcript. But the court may well remember the final sentence in this paragraph. What would be illogical in the tribunal's view would be to read Article 9 as though it treated a person as an investor, even if that person had long since ceased to hold the investment in question. Plainly treating it as a jurisdictional issue including with reference to Article 9, because of the considerations around the existence and the scope of the consent to arbitrate. And it's doing so, having done a review of the authorities, including Daimler and Avon and CSOB, in order to consider the situation where conduct is impugned in the context of a case where there is then a disposal of an asset, and the tribunal needs to decide if it has jurisdiction over that case.
So these paragraphs treat the critical date as the date of commencement of arbitration rather than the date of the breaches alleged. So is that your case?
I'm very sorry, my lord. These paragraphs treat the critical date as a date of commencement.
Commencement of arbitration. You have to own the asset at the date of commencement of arbitration, not that you have to own the asset at the date of the alleged breaches. So I'm just saying, is that your case, that the critical date is commencement of arbitration?
I'm grateful, my lord. This case, our court, does treat the critical date for the purpose of the objection in front of it as the date of the commencement of the arbitration. So this is a date of commencement
Yes.
case and an objection relating to it. So that is only part of the objection that the Czech Republic says is live or will be live before the first instance court if we prevail on this appeal. You'll remember, my lord, that the objection that the Czech Republic says is live, as I discussed with my Lord Justice Popplewell this morning, was that conduct by the state that is impugned after the disposal of the investment gives rise to a jurisdictional issue, but also that the lack of investment at the date of commencement gives rise to a jurisdictional issue. It's that second point, the Alcor point, that my learned friends say, no, that is not live anymore in these proceedings. But that's where the disagreement is that we canvassed this morning.
So you say it has to be both?
In terms of the critical date, an objection can be taken on both grounds, my lord, in terms of whether there is a general principle of international law that the date of commencement is a critical date at least for the determination of jurisdiction. That is what Alcor says, and that is a correct statement of law. But in terms of what is necessary for our objection, it's actually put on two slightly different bases. The first is that there is no investment by an investor in the context of post-dating conduct, and also that you need to have an investment at the date of commencement. So it's a slightly different point. So the critical date question arises in relation to date of commencement, but not so much in relation to the first of those.
But the interpretation of the offer to arbitrate, which you invite us to accept, is that somebody must be a qualifying investor at both the date of the alleged breaches and the date of commencement of arbitration. Is that right?
I accept that, yes.
Yeah.
I accept that. Thank you.
Sorry to. Are they in section 30 terms? Different arguments in the sense that first there's an arbitration agreement under. Second is a question as to whether, even if there is, the claim falls within the scope of that agreement under C. It may not matter, but strikes me as that may be the difference between the two.
I would embrace that, my lord, and agree. It is something that I might give further thought to over the course of my submissions, because that type of allocation within section 30 is not one that I had turned my mind to, but thinking through it now, that would be an appropriate allocation and, of course, is resulting in the objections of both variants being jurisdictional. Oh, and I should make the point, which I'm assisted with my gratitude, that these arguments, the two variants as I've been calling them, are alternative arguments in terms of the objection. If we win on either of those, we win on the objection. But of course, my lords, my lady, that's not for this court to determine. It's the point of characterisation that my Lord Justice Popplewell's question about the categorisation in section 30 goes to. The next point I had intended to take in my submissions was a point about the additional case law, which, though not squarely considering the facts of the objection before the court, or which we say is live before the court, helps situate that objection as one which must be jurisdictional. I will take this quite quickly because in the course of my rather long run-up this morning, in response to the exchanges that the court and I had yesterday, I have covered much of this material, so I will be brief. As the court knows, I've sought to situate the objection that is in this appeal by reference to other cases that are dealing with slightly different objections, but still objections going to the existence and the scope of the consent to arbitrate in the context of cases about the timing of the acquisition and disposal of the investment. One line of cases that we haven't touched on is at page 18 of my skeleton. I think that was CB3 from memory. And this is where the court may recall that a variety of cases are set out at subparagraphs A to F of paragraph 55. Now, these cases are illustrating the principle that for a tribunal to have jurisdiction, a claimant must show that it owned or controlled the investment at the time of the alleged treaty breaches. I'll just pause so that the court can cast its eyes down the articulation of principle that are taken from those cases on that page. Now, it is said against me that these tribunals were considering different objections, such as, but not exclusively, the claimant had not acquired the investment before the date of the breach. And it's also said by my learned friends that the treaties in issue had different wording. Now, I accept that. I accept that these cases are considering a different objection and the treaties have some variation of wording between them. But the point is, across those different treaties and different wording, and where there were those slightly different objections in issue, tribunals reiterate that they do not have jurisdiction unless the relevant test for the existence of an investment under the treaty is satisfied at the time of the alleged breach. And as I've said, that principle may not be the one that the first instance court in this case would need to squarely decide. But for the characterization issue, it assists by situating that objection that the Czech Republic advances here as one that is properly jurisdictional. As I said when I was wrapping up the first stage of my submissions this morning, it would be an unusual result for just this issue relating to the existence and scope of the consent to arbitrate in a disposal of assets case to be regarded as admissibility, but for all the related objections going to the acquisition or disposal of an asset and the timing of the alleged breaches to be jurisdictional. Our case would be an island on its own of admissibility, surrounded by closely related but different cases which treat the matter as one of jurisdiction. As I've said, that's a point which I know we've canvassed at some length this morning, but I did just want to remind the court of those cases on page 18, because there are, I accept, a greater number of awards that consider that point reflected on page 18 than Phoenix and Vauclinghouse, which consider the point about the conduct that postdates the disposal of the investment and the impact on jurisdiction of that event. But it is not just one or two cases that surround the island that my learned friend proposes that the court builds. There are plenty of cases that I have taken the court to on page 18, and then also in my skeleton on page 21. Which provide that context and that situation that I've been referring to. My lords, my lady, I wish to move now to a separate point that has arisen between the parties. Now, it may well be that the court does not need to get into this point at all, because the answer to the characterization issue is given by the submissions that I've already made, particularly by reference to Article 9 and Article 2 of the treaty and the authorities that I've taken the court to. But I do think I need to address it briefly, and it's the Tatneft point that the court will have seen in the parties' skeleton arguments. Could we please start by going to the March judgment of Mr. Justice Foxton below, at paragraph 147, that references CB/12/51. Now, the court, I suspect, will be very familiar with these three paragraphs that are on the screen. Paragraph 146 is really the one paragraph in the judgment dealing with the Stava June 2011 objection. The next paragraph at 147 is where the judge recognises that a tension exists between his conclusion and that of Mr. Justice Butcher's in Tatneft. But his lordship concludes that Tatneft could be distinguished as dealing with a different situation. Now, it is common ground that in Tatneft the issue was whether an objection that the investor had not made its investment before the date of breach was jurisdictional. And Mr. Justice Butcher, of course, held that this was an objection to substantive jurisdiction. Another indication of a finding, this time judicial, which makes the island of admissibility that my learned friends propose in relation to the Czech Republic's objection all the more lonely. I'm going to start by dealing with this point, the Tatneft point, by going to Mr. Justice Butcher's judgment in Tatneft. It's at LA 18, which is hard copy bundle 4. I would like to start first by looking at the relevant arbitration agreement at issue in Tatneft, which is at paragraph 58 on page 7 in the Opus bundle. Pardon me, it's paragraph 58, so it may well be page 17. I've got a mistaken reference. It's page 14 in the Opus bundle. No, it may well be that my paragraph reference is mistaken. I apologise to the court. Can we go back to page 7 in the Opus bundle, please, operator? I apologise to the court, I have an incorrect reference, but I can simply read it into the record. The relevant arbitration clause at issue in Tatneft stated that any dispute between one contracting party and an investor of the other contracting party arising in connection with investments shall be set out in notification, and so on. So in my submission, that is very similar wording to what we have in Article 9 of our BIT. I'm grateful to Mr. Webster behind me, who has clarified it's in paragraph 48 of the judgment, which is opus page 12. It's at the end of that paragraph there. So I suggest that the wording that one sees at the end of paragraph 48 is functionally very similar to the initial wording that we have been looking at in detail in Article 9 of our BIT. Now that the court has that treaty language in mind, I'd like to turn to where Mr. Justice Butcher deals with the timing objection that I referred to, and that starts at paragraph 82. It's under the heading, the timing point. There, His Lordship records, Ukraine contends that in accordance with international investor state jurisprudence, the relevant state's offer to arbitrate should be construed as limited to disputes in respect of events that arise after the claimant makes a qualifying investment protected by the BIT. Ukraine contends that Tatneft acquired the Ambrose and C Group shares after the relevant dispute relating to those shares had already risen. So this is the predating point that we have seen on page 18 of my skeleton, and which was also discussed in Phoenix and Czech Republic. His Lordship continues at 83. Tatneft contends that there is no basis for saying that the offer to arbitrate in the BIT was limited to matters arising after the claimant acquired a qualifying investment. It's submitted that Article 9 does not expressly include any such limitation, and construed in accordance with the principles I have set out, it could not be interpreted as imposing such a restriction. In any event, even if there was a temporal limitation, it was satisfied in the present case. So in some respects, there are echoes of what we have seen in paragraph 146 of Mr. Justice Foxton's first judgment in this case from March, namely that there is no express language in Article 9 of our BIT containing a limitation. Importantly, Mr. Justice Butcher continues in paragraph 84 to look at the investor state cases on the point, including the Levi and Peru case. He starts at the bottom of that page. In the award on jurisdiction and admissibility rendered in the case of Philip Morris and Australia, the tribunal referred at paragraph 528 to an earlier award in the case of Grempsatel and Peru. Grempsatel and Peru is another denomination for Levi and Peru, two claimants whose names are sometimes interchanged. So when one sees Grempsatel, one can equally read Levi. In Grempsatel, part of the tribunal's award was as follows, and then it quotes from paragraphs 146 to 148 of Levi. It is clear to the tribunal that where the claim is founded upon an alleged breach of the treaty's substantive standards, a tribunal's jurisdiction is limited to a dispute between the host state and a national or company which has acquired its protected investment before the alleged breach occurred. In other words, the treaty must be in force, and the national or company must have already made its investment when the alleged breach occurs, for the tribunal to have jurisdiction over a breach of that treaty's substantive standards affecting that principle. That's the predating point that we are familiar with. Then the next paragraph, 147, has two sentences in it. And it's significant that there are two for reasons I'll come back to. The first is that this conclusion follows from the principle of non-retroactivity of treaties, which entails that the substantive protections of the BIT apply to the state conduct that occurred after these protections became applicable to the eligible investment. Sentence number 1. Sentence 2 then continues. It's articulating a general principle in which the previous sentence, the predating point, is captured. Because the BIT is at the same time the instrument that creates a substantive obligation forming the basis of the claim before the tribunal, and the instrument that confers jurisdiction upon the tribunal, a claimant bringing a claim based on a treaty obligation must have owned or controlled the investment when that obligation was allegedly breached. 148 then concludes, a claimant must therefore prove that it had already acquired its investment at the time of the impugned conduct, because Levi was dealing with a predating situation. Now, I accept that Levi is dealing with that predating situation, and so in those circumstances, the principle of non-retroactivity of treaties is a principle that would be invoked in the reasoning to determine that type of objection. But the statement of principle in Levi and Peru, as quoted and relied upon by Mr. Justice Butcher, is not limited solely to the principle of non-retroactivity in the first sentence of paragraph 147. The second sentence of 147 is a statement of the more complete principle. Because the BIT is at the same time the instrument that creates the substantive obligation forming the basis of the claim before the tribunal, and the instrument that confers jurisdiction upon the tribunal, a claimant bringing a claim based on a treaty obligation must have owned or controlled the investment when that obligation was allegedly breached. And that, with respect, is correct. The nature of a bilateral investment treaty is that it creates obligations and confers jurisdiction. This touches on the exchange that I had with my Lady Justice Andrews yesterday. There are numerous cases that say one result of that conduct that predates the investment is not within the jurisdiction of the tribunal. That's the predating point. And then there are cases like Phoenix and Vucklinghouse that say conduct post-dating the investment is not within the jurisdiction of the tribunal. What matters in this statement of principle in Levi and Peru, for present purposes, is that the point is a jurisdictional one. It is not a matter of implying terms into the arbitration clause or relying on the non-retroactivity of treaties principle as the complete expression of the point. Rather, it is a matter of delineating the scope of the consent to arbitrate and the jurisdiction that it confers on the tribunal. For the purposes of the present appeal, that is entirely in line with what the Czech Republic has been submitting in relation to the terms of the treaty and the previous investor state authorities. If all these points are jurisdictional, as taken in Levi and Peru and as concluded by Mr. Justice Butcher in Tatneft, in my respectful submission, so too is the point that the Czech Republic advances in this objection. Now, Mr. Justice Butcher's conclusion is a few paragraphs down at paragraph 87, please, operator. I'll just leave the court to read paragraph 87. Now, that is the application of the principle of jurisdiction to the facts of that case, which I accept is a case where the impugned conduct predates the acquisition of the investment. And if one now turns back to the judgment of Mr. Justice Foxton from March, one sees how the judge, in my respectful submission, did not engage fully or even at all with the general principle that one sees in Levi and Peru in the second sentence of paragraph 147. The court may well wish to keep open Levi and Peru while also opening up his lordship's judgment, which is at CB 12. And we'll start at paragraph 134 on opus page 47. Now one can see that in paragraph 134, this is where his lordship turns to the Tatneft decision. And if one looks down to 137, his lordship discusses the timing objection that we've just been looking at. He notes, the second was the contention that Tatneft had acquired the relevant asset after the breach of the treaty had occurred. In concluding that this issue was jurisdictional, at paragraph 84, Mr. Justice Butcher cited the following passage in Levi and Peru, before he then goes on to quote the same paragraphs from Levi that we have just seen quoted in Tatneft. If we go over the page in the March judgment, please, operator. Sorry, on the right-hand side of the screen. One can see that the quote from paragraph 147 from Levi and Peru is set out there by Mr. Justice Foxton, including both sentences. Now, Mr. Justice Foxton then deals with the effect of this at paragraph 147 of his judgment, which we looked at the start of this part of my submissions. That's at CB 12, page 51, please, operator. This is where his lordship distinguishes the conclusion by Mr. Justice Butcher in Tatneft, in essence saying the predating point is jurisdictional, but the post-dating point is not to be approached in the same way. However, when one reads this paragraph in his lordship's judgment, one sees that it only engages with the first sentence from paragraph 147 in Levi and Peru. That's the sentence about non-retroactivity. An entirely appropriate sentence when you're dealing with a predating point. But no attention is given by his lordship to the second sentence in paragraph 147 of Levi and Peru. That second sentence is on the left of the screen. And it deals with the principle that an investment treaty creates obligations and confers jurisdiction. And so a claimant can only impugn conduct within the time range of its investment. In my respectful submission, the judge below wrongly placed no weight on the second sentence from paragraph 147 in Levi and Peru, which reflects the very points that I have been making over the course of this appeal.
I have some difficulty with the logic of the reasoning in the second half of 147 of Levy, because it must surely all depend upon the terms of the arbitration clause. If you had a clause which made clear that the offer was being made, the offer to arbitrate was being made to any person who is or has at any stage been an investor, then that logic wouldn't apply, would it?
My lord, that would take you into the Mondev territory. And indeed, Mondev is distinguishable because of its treaty language.
But doesn't that illustrate why, as a general proposition, the second half of 147 isn't sound?
With respect, my lord, I wouldn't put it so high as saying is not sound. I would accept that the second sentence in 147 of Levi ought to be read as saying, unless the treaty terms provide differently. And indeed, that's the language that is used in Alcor as well. But otherwise, in terms where the treaty has the language that is contained in our treaty, which is the same language that was being considered in Tatneft as well, then in my submission, there are no treaty terms that could operate differently.
I know you say that's the result for which you contend, but just looking at it by way of reasoning, what seems to be being said in 147 in the second half is the instrument creates the substantive obligations, the instrument contains a clause that confers jurisdiction, and therefore claimant bringing a claim based on a treaty obligation must have owned or controlled the investment when that obligation was allegedly breached. That simply doesn't follow from those two premises, and its fallacious reasoning is illustrated by the fact that you've got different terms in the instrument which create the obligation from those which define jurisdiction, and those that define jurisdiction can, in some cases make it perfectly clear that they apply to previous investors. That's the difficulty I have.
I can well understand that, my lord, and I do maintain the submission that that is going to be primarily answered in a given case by the terms of the treaty.
Yeah.
When one recalls the language in NAFTA, which expressly includes that has made language, so looking back in time for a past tense existence of an investment, then that is a point, as Alcor emphasised, does mean that this general principle may well not apply, and that's what the Mondev Tribunal held. But in the absence of treaty language, in my respectful submission, the start of the second sentence in 147 does lead to the jurisdictional consequence at the end of the provision.
I understand that. I just wonder whether your criticism of Mr. Justice Foxton is quite fair, because he does address the scope of the clause, which, if he's right about it, I know you say he's wrong about it, is an answer to this reasoning, isn't it?
Well, I can accept that it may be an answer to the reasoning in terms of the substance, in the sense that that would be there to argue with his lordship if the matter returns back before him. But in terms of the issue for this court, with respect, it doesn't answer the point that it is still properly characterised as jurisdictional. So the first point about non-retroactivity, on which his lordship, Mr. Justice Foxton, did place reliance, is in my submission actually what is the irrelevant part of paragraph 147 of Levi and Peru. The relevant part is the second sentence, and while there may be a debate to be had on the substance of the objection, what is beyond debate and confirmed by that provision in that award is that the point is jurisdictional. So while I appreciate that looking at the substance of the objection may elucidate the question of characterisation, what is in my submission clear from Levi and Peru, and was not fully taken into account by the judge below, is that the point is to be characterised as jurisdictional, given the timing point. And one way to test this, my lord, if I may, is that one is looking at ultimately the conclusions that Mr. Justice Butcher reached in Tatneft. And he says the predating point is jurisdictional. The post-dating point, if I can put it quite crudely, is really just the flip side. It's the other side of the same coin for that very timing point that Mr. Justice Butcher was considering. So in those circumstances, the starting point in my submission is that it would be strange for one side of that coin to be treated as jurisdictional and therefore subject to the court's review, but the other side of that coin to be treated admissibility and solely within the exclusive competence of the tribunal. That, I think, as a starting point, which is supported by all of those cases and principles that are situating the Czech Republic appeal, I think means that that error from his lordship below is apparent, at least in relation to the characterisation point. And that is only further confirmed by paragraph 147 in Levi and Peru. Can I come to a related point in Mr. Justice Foxton's judgment? Operator, we can take down Tatneft now, so it's a little bit easier to see the March judgment on the screen. Could we please put up the previous page from the March judgment showing paragraph 146? This is the paragraph where the judge makes an equivalent point to the one Tatneft made before Mr. Justice Butcher, which was rejected. In essence, the point is that Article 9 of the BIT does not expressly limit the offer to arbitrate to breaches which occur when the investor still owns the investments. The judge goes on to conclude in paragraph 146 in the final sentence that the Czech Republic's position requires the court to read into Article 9 a limitation which is not expressly stated, something that the applicable principles of interpretation make a challenging task. With respect, that is not correct. The Czech Republic's approach does not require a reading into Article 9 of a limitation which is not expressly stated. What is, I say with respect, conspicuously missing from this paragraph in the judgment is any reference to Article 2 of the BIT. As I've explained, it's not possible to read Article 9 separately and in isolation from Article 2. and the stipulation in Article 2 that the treaty as a whole, which includes Article 9, only applies to investments by investors. When one puts Article 2 and Article 9 together, as one must, there is nothing to read into Article 9. To the contrary, in my submission, it is a clear indicator in Article 2 as to the scope of the BIT, and thus the scope of the jurisdiction that the tribunal can exercise. And that error of the judge, I say with respect, is not only evident when one looks at the appropriate interpretation of investment treaties. It is also evident when one looks at decisions of other international legal fora. I'd like to take the court to the recent judgment of the International Court of Justice in the Azerbaijan and Armenia case that is referenced in the skeletons. The court will no doubt be aware of the Nagorno-Karabakh conflict between those two countries. And this case is one that arises out of it. In this listing before the ICJ, Azerbaijan instituted proceedings claiming that Armenia had engaged in a process of ethnic cleansing.
I'm so sorry, where are we?
So the judgment is at LA 29. I was just introducing it in general terms by saying the allegation was one of ethnic cleansing, both in its territory and in Azerbaijan's territory. This and other conduct was said by Armenia to breach the Convention on the Elimination of Racial Discrimination. Now, Armenia raised jurisdictional objections to Azerbaijan's claim, and you can see those summarized in the judgment at LA 29, page 17. I suspect I'm too late, but the hard copy volume is volume 6. One starts at paragraph 27, my lords, my lady. One can see that the court records both Azerbaijan and Armenia are parties to CERD, the Convention on the Elimination of Racial Discrimination. Azerbaijan acceded to it on 16 August 1996 and Armenia on 23 June 1993. The convention entered into force for each party on the 30th day after the date of the deposit of its instrument of accession, i.e. on 15 September 1996 and 23 July 1993, respectively. On to 28, and it's the first jurisdictional objection recorded therein that matters. Armenia argues that the court lacks jurisdiction to entertain Azerbaijan's claims concerning acts that took place prior to the entry into force of CERD as between the parties on 15 September 1996, or that such claims are inadmissible. One can then see the issue is crystallized at the start of paragraph 29. In their pleadings, the parties do not dispute that claims relating to alleged acts that occurred before 23 July 1993 are outside the temporal scope of the court's jurisdiction, and that claims concerning alleged acts that occurred after 15 September 1996 fall within the scope of the court's jurisdiction ratione temporis. They differ, however, as to whether the court has jurisdiction over Azerbaijan's claims concerning alleged acts that occurred between 23 July 1993 and 15 September 1996, the period during which Armenia was a state party to CERD while Azerbaijan was not. In its first preliminary objection, Armenia contends that the court lacks jurisdiction ratione temporis over those claims, or alternatively, that they are inadmissible. Two short points here. The first is that the nature of the objection is what time period the court has jurisdiction over in respects of the acts impugned by Azerbaijan. Second point is that Armenia was putting before the court a suggestion that the point was jurisdictional, or alternatively, one of admissibility. So as part of what the court does here, it needs to address whether an objection to the temporal scope of the compromissory clause in CERD is jurisdictional or one of admissibility. Now, pausing there before we read on in the judgment, let's just look at the compromissory clause contained in the third. That's just above on the screen at paragraph 26. We can just go up a little bit, operator. Yes, there we go. Any dispute between two or more states parties with respect to the interpretation or application of this convention, which is not settled by negotiation or by the procedures expressly provided for in this convention, shall, at the request of any of the parties to the dispute, be referred to the International Court of Justice for decision, unless the disputants agree to another mode of settlement. Now, it's important to note that there is no express language in the compromissory clause which is stating the temporal scope of the court's jurisdiction. Much like the arbitration clause in our investment treaty, and much like the arbitration clause we have seen in other cases like Phoenix and Levi and others. So a question is whether the court sees any difficulty in interpreting that compromissory clause in Article 22 of the third in a way that has a temporal jurisdictional limit, which is not expressly stated therein. And the answer is that no, the court doesn't have any difficulty. What follows from the bottom of this page, or over the page, at paragraph 30 to 40, is a summary of the parties' arguments. I won't take the court to that now. But then we come to paragraph 41, which is on page 20 in the opus. 41 frames the issue, but I will pick it up at paragraph 42. Regarding the first question, the court recalls that under Article 22 of third, in order for the court to have jurisdiction, only states parties may submit their dispute to the court for adjudication, and the subject matter of the dispute must concern the interpretation or application of the convention. This article specifies the scope of the court's jurisdiction, ratione personae and ratione materiae, but it contains no language defining the temporal scope of the court's jurisdiction. Echoes of Mr. Justice Butcher and Tatneft there. And again, I respectfully suggest at odds with what Mr. Justice Foxton found below. The court notes that there is no express language in Article 22 of the third defining the temporal scope of the court's jurisdiction. But as we will see when we come to its findings, that's no barrier to the treaty being interpreted as including such a limitation, and that limitation being jurisdictional. Paragraphs 43 and 44 are the next relevant paragraphs. The court considers that Armenia's reference to the principle of non-retroactivity of treaties raises an issue concerning the relationship between the substantive provisions and the compromissory clause of the third. So coming back to that point, that there is a feedback loop between provisions that both confer jurisdiction and set out the substantive obligations. The court then refers to the non-retroactivity principle in Article 28 of the Vienna Convention, and I pick it up slightly lower down after the parenthesis in the middle of the paragraph. This principle defines a temporal application of the substantive provisions of a treaty for a state party and to which acts its treaty obligations apply. It specifies from which point in time the responsibility of a state party may be engaged for its conduct which is not in conformity with its obligations under the treaty. Moving on to paragraph 44. I won't read the first two sentences. But picking it up in the middle, the court observes, however, that the question before it is not whether Armenia was bound by the obligations under third during the relevant interval. Rather, the question is whether Article 22, under which Azerbaijan has given its consent to the court's jurisdiction, provides a jurisdictional basis for the court to entertain Azerbaijan's claims in respect of alleged acts that took place before Azerbaijan became party to the convention. So again, this will be familiar from its echoes. The court will recall the second sentence in paragraph 147 of Levi and Peru, and the court will call the approach of Mr. Justice Butcher in Tatneft. that makes clear that a treaty can both create obligations and confer jurisdiction. And when that happens, it is entirely within international law principle for a limitation on the scope of jurisdiction of the tribunal or court to arise. It may not be stated in the arbitration clause or the compromissory clause, but that is not a barrier to that limitation being included. And it is particularly not a barrier where, in the context of our treaty, one has clear language in the context of Article 2, which provokes that limitation in Article 9. And the limitation that emerges from the analyses that we have been reviewing, including here of the International Court of Justice, is that jurisdiction will only exist in respect of the period that the substantive obligations in the treaty apply. In the Azerbaijan and Armenia situation, that was the period when the substantive obligations bound those states. And we can see that in paragraphs 45 and 47, which are both short. The court considers that subject to any reservation or express indication to the contrary, the temporal scope of the court's jurisdiction under a compromissory clause is determined by the scope of the temporal application of the substantive provisions of a treaty between the parties concerned. And picking up at 47, in light of the above, the court considers that in the present case, the temporal scope of the court's jurisdiction under Article 22, third, must be linked to the date on which the obligations under third took effect between the parties.
What, in a nutshell, do you get from this case, which seems to be dealing with a very different situation from what we're concerned with, and is interpreting a clause in a treaty between two states?
2 points, my lord.
Yep.
The first is the proper characterization of an objection relating to timing when delineating the scope of a consent to arbitrate or a compromissory clause is jurisdiction. One can see in paragraph 45 that the tribunal concludes the matter as a jurisdictional issue. It had been put before it.
It was anything else.
Pardon me, my lady?
It wasn't suggested that it was anything other than a jurisdictional issue.
To the contrary, with respect, it was pleaded before the court that the point could either be jurisdictional or admissibility. And so when both of those propositions were put before the court, and the court reaches a conclusion that Article 22 of third contains a temporal limitation on its jurisdiction, in my submission, that is an indication that the court sees this as properly characterized as jurisdiction. The second point that one takes from this judgment is the point about whether Article 9, the consent to arbitrate in our case, the analogue to the compromissory clause in the third, can be interpreted to have a temporal limitation on jurisdiction within it, even though it is not expressly stated. Your Lordship will recall that in paragraph 146 of Mr. Justice Foxton's judgment below, his Lordship said that principles of interpretation make that conclusion difficult to support. But with respect, that is not correct for the reasons we have seen in the investor state authorities we've been to, and now also the ICJ judgment that we are discussing here. I see the time, my lords, my lady. If I could just take a moment to briefly check. My lords, my lady, I may have some further brief points on Azerbaijan, but I will probably be able to do those more briefly if this is a convenient moment to break.
Yes, all right. How are you doing generally? When do you expect to conclude your submission?
I will be able to give a more precise answer after the break, but I am approaching the end, so there will be no difficulty in me finishing during the next session, certainly.
Very good.
And likely in the first half of it.
2 o'clock.
So you had about half an
Do you mind if I give you an indication of the
hour. Yeah, and how long will Graham be? Graham, do you have any sense? Difficult. You'll probably get a couple of hours today. Yes, so maybe a bit late.
I think, Lucas, I get the impression you're going to be another hour or so.
Roughly, let me look at it.
So I will start.
Yes.
So
You'll need at least a whole tomorrow
basically,
morning.
until Lucas started yesterday,
Yeah.
you had taken all the time on your side.
Yes.
So if you start with proposition, we have 2.5 days, you have 2.5 days. Lucas spent an hour yesterday, and then whatever time he spent today, and that obviously comes out of our 2.5.
Right. Well, let's because obviously they were not interested in anything further on Stockland. But let's. I think we've got enough time. Basically, we.
Oh, I think we've got enough time. Yeah.
we'll
But we're approaching on the basis that we have.
you want to use your Stockland time on the other two.
Yeah, that was in the direction that we could use our time as we see fit.
Okay. Let me discuss. But let's.
Anyway, we are definitely definitely aiming to finish this week. I mean, I would have thought.
Yeah.
Depends on the questions. Obviously, I might be a total of 4 hours or so, because I want to keep time back for my reply.
Yeah. Yeah.
And I think I've got about 6 hours.
So then I'm likely to be up on admissibility tomorrow afternoon, and then we have control on Friday, and then your reply Friday afternoon.
And the replies will be in the same order. You've got something on your forehead.
Yeah, there are only 2 replies now.
Basically, they wanted to.
Okay.
Yeah.
They wanted to.
A long time.
Jump his real time.
Yeah.
It's just a white header, actually. We've got one road.
Thank you for drawing that.